And we have new information about the possible criminal referrals coming from the House January 6th committee. A new report suggests the committee is considering criminal referrals for former President Trump and at least 4 others. That report says that 4 people are former White House Chief of Staff Mark Meadows, lawyer John Eastman, former Justice Department official Jeffrey Clark, and Mr. Trump's former lawyer, Mayor Rudy Giuliani. The January 6th committee sat down with all of them except for Mark Meadows. Meadows refused to testify but did hand over more than 2,000 text messages. As for Eastman and Clark, they both sat down with the committee but both invoked their Fifth Amendment rights, which protects against self-incrimination. And as for Giuliani, he was interviewed by the panel back in May for about 9 hours. The report also says that while those names are being considered, nothing has been formally decided. The report makes clear that the committee has not officially decided who, if anyone, to refer to the Department of Justice for prosecution and for what offenses. Note that the Justice Department does not indict, grand juries do, but the Justice Department presents its evidence to the grand jury and then asks for an indictment. And we told you about this one last night. The Justice Department pointing fingers at former President Trump's legal team and asking a federal judge to hold the lawyers for Trump in contempt of court because none of the Trump lawyers want to assume the role of custodian of records. Well, according to CNBC, federal judge Beryl Howell has denied that request of contempt. The DOJ argued that the former president's team failed to comply with a subpoena issued in May. That subpoena required his office to return all classified documents in its possession. In recent weeks, Trump's team has searched his other properties and turned over 2 items to the government that they just found. A spokesperson for the former president says Mr. Trump will continue to be transparent and cooperative even in the face of the highly weaponized and corrupt witch hunt from the Department of Justice. Former U.S. Attorney for the Northern District of Alabama and Vice President General Counsel of Gray Analytics, Jay Town, joins me. I guess, Jay, that you could take a bit of a victory lap tonight because I don't think you thought that a judge would hold those lawyers in contempt. Do you have any thoughts tonight? You want to take a victory lap of someone?
I do not, but I do think that it was important that you and I discussed this last night and how, you know, it was just, I think you mentioned that you thought it sort of looked like going to the principal or into the principal's office and tattling or, you know, going to the judge and really what a colossal, in a lot of ways, you think of the equities that were wasted on this hearing. 1, it didn't work. 2, the public has now, you and I are talking about it for a couple of segments in consecutive evenings. And the Justice Department, again, you're trying to indict this man. That's the worst you can do to him. Holding a billionaire in contempt and having daily fines assessed is not the worst you can do to him. And so it just seems like the focus needs to be, obviously there's a lot of contention between the Trump team and DOJ. That's understandable from maybe both sides. But I just feel like they're not keeping their eye on the ball.
All right, let me go back to August 5th. I mean, if the Justice Department intends to indict the president, what it would go back to is probably August 5th when the judge signed that search warrant for Mar-a-Lago. And I went back and read it today. And what it says, in part, it says the government is conducting a criminal investigation concerning the improper removal and storage of classified information. So in order for them to prevail on that count, they also say as well as unlawful concealment or removal of government records. But in order to prevail on the classified information, they've got to prove beyond a reasonable doubt that it's classified. And you and I discussed this last night. There are rules for everybody but the president for declassifying. A president has no rules. He can do it exactly what he wants. So it seems to me, going back to this, I don't know how they could convict him on this because I don't know how they would show that those documents were classified because Trump's not going to take the stand and say that. So tell me, how does the Justice Department ever show those documents are classified?
Well, I mean, they're going to show the markings, the classifications and things like that, and probably ask the jury to draw some circumstantial conclusions. But you're right, Greta. Beyond
a reasonable doubt? I mean, that's the problem is that they've got to show they're classified. And if they're in the possession of the president and he can do anything he wants to declassify, no rules, none. He can do it any way he wants. He can think it. And say, I don't know how the government, I don't know how they prevail.
it's important for viewers to understand that there has to be an ultimate classification authority, and that is the commander-in-chief. And that's why the rules apply to everyone but him. And so you're 100% right. I do believe he can wave a magic wand silently in a dark room and declassify documents and never tell anyone. It's a horrible practice. We shouldn't want that to be the way we declassify. But that is the law of the land right now, and it was when he left on January 20th. And so you're right. The grand jury is going to be the easy part if it actually gets past that. The trial is going to be a whole nother set of obstacles for the government.
See, I see what is an immaterial element of the crime of having classified information is that they prove it's classified. And so they've got to prove that it's classified, which would include proving that the president didn't just wave a wand and declassify. You can't ask the jury to guess that he didn't do it. And he's never going to take the stand and say, he's never going to say that he did or he didn't. I mean, they've still got to prove it beyond a reasonable doubt. And I just don't understand, looking ahead, how they can do that, how they can prove that.
The sort of maybe fallback might be that there's records that relate to national defense, which is in that sort of same mishandling statutes, and they don't have to be classified documents, so Jay, it's possible.
But yeah, Jay, they could be the most incredibly secret information that we never want to get out, but they still have to prove that element. That's the problem.
I agree.
Even though it's like we all look at this and say this should be classified, that still doesn't get around the fact that they have to prove it.
And there's a whole slew of privileges that the courts have not decided yet, and that's going to be an interesting motion practice too if it gets that far.
Anyway, it's going to be fascinating if we get that far. We don't even know if we'll get that far, but it's an interesting discussion between two lawyers. Jay, always nice to see you. Jay Town, thank you.